Imagine waking up every morning, gathering your belongings for school, and putting on your coat, then walking past an all-white school that refuses to accept you just because of the color of your skin. Now imagine walking 21 blocks away from your house, just to attend an all-black school so that you can have a chance to get a decent education. Thus begins the case of Brown versus the Board of Education. To truly understand the case, you must understand what happened before. Plessy versus Ferguson. The state of Louisiana enacted a law that required separate railroad cars for blacks and whites. In 1892, Homer Plessy took a seat in a whites-only car of a Louisiana train and was arrested when he refused to move. The court ruled that the 14th Amendment could not have been intended to abolish distinctions based upon color or commingling of the races. Now fast forward 62 years in the future. Segregation is still well and alive, racism protected by the law. There are separate amenities for whites and separate amenities for colored people. African American students are forced to go out of their way just to attend school. School officials at an elementary school in Topeka, Kansas denied 8-year-old Linda Brown permission to attend the all-white school that was just 5 blocks from her house. Instead, she was assigned to an all-black school 21 blocks away from where she lived. Linda Brown's parents filed a lawsuit to force the schools to admit her to the nearby school that was for white students. The court had to address the Equal Protection Clause of the 14th Amendment and had to determine whether segregation of children in public schools solely on the basis of race deprived the children of equal educational opportunity. Thurgood Marshall and other NAACP members argued that the operation of separate schools based on race was harmful to African American students. Attorneys for Topeka argue that separate schools for non-whites in Topeka were equal in every way and were in complete conformity with the Plessy standard. The court unanimously ruled that separate schools were not equal. Chief Justice Warren wrote in his first and probably most significant decision, segregation in public schools is a denial of equal protection of the laws. To separate some children from others of similar age and qualifications solely because of their race generates the feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. Segregated schools were found to be unconstitutional and were therefore banned. This law was met with much resistance. Some schools even went as far to close down and open up private academies. Some states, such as South Carolina and Alabama, began to fly the Confederate flag on their state capital. Now fast forward 62 more years into the future. Schools are now desegregated, children of all colors exist and thrive in the school system, and are all guaranteed the same educational opportunities. And we have the NAACP, Thurgood Marshall, Justice Warren, and many others to thank for the progress that we've made today.